The Honourable Malcolm McCusker, barrister, former Governor of Western Australia and shark wrangler, gives his insider view of his work on several high-profile wrongful conviction claims in Western Australia. In particular, Mr McCusker reflects upon his work in the case of Andrew Mallard, one of this country's most recognisable and egregious miscarriages of justice.
Thank you very much to the organisers of this conference for doing so, because it is a very important issue that's being considered, as Justice Michael Kirby has said earlier in his introductory remarks. I'll deal with the three cases referred to. The first of those that I'd like to deal with is the Mallard case, the final decision which was given in 2005, Australian High Court Appeal 68. And to go back to the beginnings very quickly, in May 1994, a jeweller, Pamela Lawrence, was found late at night in a pool of blood in her jewellery store. She'd been bludgeoned to death. In July 1994, less than 2 months later, a tall, 6'7", gangly, eccentric 31-year-old youth who suffered from bipolarity, called Andrew Mallard, was arrested at a psychiatric hospital and charged with the jeweller's murder. In 1995, after a 10-day trial in which he was represented by a legal aid lawyer, Mallard was convicted by a jury and sentenced to life imprisonment. I just pause there to note that Mallard, in fact, his legal aid lawyer was very inexperienced, unfortunately. He never done a murder trial in his life, and very wisely asked the judge, well before the trial date, for an adjournment so that he could engage a QC who was prepared to act but was unavailable on the trial date. The adjournment was refused, so the hapless legal aid lawyer, in fairness to him, was taking on a case which he admitted he was not fully prepared for. Anyway, Mallard was convicted, sentenced to life imprisonment. The case against him depended on what was said to be his admissions or confessions made to the police. 2 of them were unrecorded by video, although video facilities were available at the time, and 1 recorded by video. There was no physical evidence connecting him to the murder. And neither his blood, nor his fingerprints, nor his DNA were found in the jeweller's shop, the scene of the crime, and none of the murder's woman's blood was found on any of his clothing. Without success, he appealed against his conviction to the Court of Criminal Appeal in Western Australia, and unsuccessfully, as Michael Kirby has said, made an application to the High Court for special leave to appeal. What was said by Michael Kirby this morning to be a dream panel, Justices Kirby, McHugh and Toohey, dream in the sense that they were certainly aware of the importance of the presumption of innocence, for example, but I think all judges are aware of that. They rejected his application for special leave. And I mentioned that over the years since then, and since the whole of the Mallard saga has unfolded, Michael Kirby, in unfairness to himself, has expressed remorse that they rejected his application for special leave at that time. It was a totally different case presented to the court then than was later presented to it sometime later. Going back to the narrative, having unsuccessfully appealed against his conviction and unsuccessfully applied to the High Court for special leave, Andrew's mother, father, and sister Jacqueline never gave up on him, never believed him guilty, and ultimately, following a petition made on Andrew's behalf, the Attorney General of Western Australia referred his case back to the WA Court of Criminal Appeal in 2002. In the following year, it heard the appeal. It lasted for a total of 10 days, spread over several months. Closing addresses were heard in early December 2003. 10 days later, the Court of Criminal Appeal unanimously dismissed the appeal. It was an extraordinarily swift rush to judgment. I made that comment at the time. However, in October the following year, Mallard was granted leave to appeal to the High Court and the appeal was heard in 2005. And in November 2005, the High Court unanimously quashed Andrew's conviction and referred it back to see whether the prosecution wished to retry him. 3 months later, the DPP withdrew the indictment, and Mallard, after spending just on 11 years in jail, walked free. Now, at the end of all that, the Director of Public Prosecutions, Robert Koch, QC, when asked for a comment about what the case revealed, is reported as saying, quote, "My perspective is that it's probably a matter of comfort for us. Our legal system is presently producing these outcomes. It's got the strength and the judges have the courage to overturn cases that should actually give us encouragement, not discouragement." They're very comforting words. As senior counsel representing Mallard both before the spectacularly unsuccessful appeal to the Court of Criminal Appeal and the equally spectacularly successful appeal to the High Court, I was asked for comment on what that case revealed, and I said, quote, "There should be concern that the justice system will never function properly unless the prosecution operates and uses its obligation of disclosure correctly. The state will always have more resources, and in my view, there should be some serious thought given to a Criminal Justice Review Commission similar to the UK." That comment, which I made then 18 years ago, was not the first time that I had urged the establishment of a Criminal Cases Review Commission. And that really is, I think, the centre of what we're talking about today. Judge for yourselves whether that comment was justified, and also consider whether what Robert Koch said about the case being a cause for comfort, that the legal system is operating to produce justice, is valid, or whether indeed it's really a matter of chance whether a wrongfully convicted person is able to obtain justice. As I said, Andrew's parents and sister never gave up on him, and after his conviction, his sister wrote to me in my capacity as chairman then of Legal Aid, and I replied 7 days later with a lengthy letter in which I expressed grave concerns about whether Andrew had had a fair trial and whether he was properly convicted. Shortly before that, I had received some relevant material from a law reformer, campaigner, Brian Tennant, his name was. And if Estelle Blackburn is in the audience, which I think she is, she'll know him very well as a really admirable law reform campaigner. He expressed doubts about Ma's conviction and explained why with some reference to some good material. A few weeks later, I received another letter, this from Andrew's parents, Roy and Grace, very well written, making very logical points about the case. Those points, they said, a number should have been raised, but were not raised by the inexperienced lawyer from Legal Aid. The letter showed them to be very intelligent people, and the points they made were certainly valid points. Those letters were all written to me and my replies before Andrew's unsuccessful appeals, which took place in 1996, 1997. I don't think his trial lawyer was the counsel on the appeal or the unsuccessful application for special leave. Not sure who it was, it doesn't really matter. Even though the appeals and the special leave application failed, Andrew's parents and sisters still did not give up on him. They raised his case with a number of people, including a member of the House of Commons in the UK. Why? Because he had been their local member of Parliament when they lived in the UK. So he got in touch with the British consul then located in Perth, and I happened then to be the honorary legal advisor to the consul, and he arranged with me to meet and discuss Andrew's case. I told him of my concerns about Andrew's conviction, based as it was on highly questionable evidence of alleged confessions. I'll tell you why I thought they were highly questionable. Just as one example, the only video recorded confession ended with Andrew saying on video, I didn't do this. These are just my conjectures, my theories as to how this all happened. And why would anyone conjecture or theorise? Well, Andrew was suffering from bipolarity, always had, and one of the features of bipolarity is what's called a grandiosity. That is, people think that they're more than they are actually in terms of value and giving theories. Anyway, I explained to them that although his appeal failed, if fresh evidence could be obtained, the case could still go back to the Court of Criminal Appeal for rehearing by petition if the Attorney General of the day was prepared to send it back based on a petition. In those days, there was no second right of appeal. And by the way, in answer to Michael Kirby, I wasn't governor when the Western Australia finally enacted legislation for a second right of appeal, which was in 2021. By then, I was back in practice. I'd ceased to being the governor. Andrew's parents and sister then went to see Colleen Egan, who was an independent journalist, and showed her the letters that I'd written. Colleen wrote to me saying, in part, your replies to them have inspired them to continue their attempts to have the case reopened. Colleen's letter to me said, among other things, that she was considering attempting to write an eminent lawman to look over the case and support the family's position. In October 2000, I received a handwritten letter from Andrew Mallard from prison, making again some further very valid points about the unjust nature of his conviction, and concluding, quote, I'm innocent of this horrific crime. Detectives did not investigate this case properly. The murder is still at large. Please help me, Mr. McCusker. For a very pathetic and plaintive plea. Following that, I wrote to Colleen Egan, sent her a copy of Andrew's letter, and I summarised again the concerns I had about the so-called confessional evidence, which was the basis of his conviction. Andrew sent me another very lengthy handwritten letter then, concluding by saying that Colleen had taken his case notes to be scrutinised by university students, which was the best she could do at the time, I think. And I sent a copy of his letter to Colleen, the covering letter saying, I find this case raises matters of great concern. I explained why and ended the letter saying the only course open was for Mr. Mallard to petition the Attorney General to have the case referred back to the Court of Criminal Appeal if fresh evidence could be obtained. Ultimately, after further correspondence, the big break in this case came through. Colleen Egan managed to meet John Quigley, a retired lawyer, but then a Labor backbencher, and she showed him my letters in which I'd expressed my concerns about the conviction. She approached Quigley with some trepidation because in his former life as a lawyer, he'd represented the police union, so I was worried that he might not be willing to say anything or do anything that would be contrary to the police, but her fears were quite unjustified. Quigley, who has since then become the Attorney General for Western Australia, and my view, sadly, is about to retire from Parliament, knew me well then in a number of different capacities, and I think it's fair to say he had some regard for my opinion. So he agreed to have a look at the case and spent many hours going through the transcript of the trial. And he came to the conclusion, as I did, that there was some injustice being perpetrated. Now, the murder weapon used to bludgeon the poor victim to death was never found by the police in their investigation, and they made a thorough search. When the police interviewed Mallard before they charged him, and who, because of his bipolarity, suffered from grandiosity and was thinking that he was helping them in their investigations and was giving all kinds of stories, sometimes lapsing, I must say, into the first person. He'd say, I did, I would have, and then he'd go back to the perpetrator. So it was a third person most of the time, but not all the time. The police asked him, what was the murder weapon? Throughout his recorded interview, Andrew, as I say, lapsed into the first person, and he said, well, I think it would have been a wrench. She would have had a wrench to open the oxyacetylene tanks, and which she would need as a jeweler. Incidentally, down the track years later, it was in fact found, and the police surely should have found, that she didn't have any oxyacetylene tanks anyway, but they also didn't discover any wrench. The police asked Andrew, however, to draw the wrench. So they gave him a piece of paper. He said, no, I'll need two pieces of paper joined together because I want to draw a life-size wrench. Oxyacetylene, he wrote on it. Sidchrome, he wrote on it. And when asked what had happened to the wrench, he said it was thrown to the river and nominated the spot in the river where he said it was thrown. In fact, the police divers who went there searching for it never found the wrench and said if it had been there, they would have found it. At Andrew's trial, Mr. Bates, the senior prosecutor appointed by the DPP, told the jury that Andrew had confessed to committing this murder using a wrench and had thrown it in the river, but they couldn't locate it. he said that the wrench that Andrew had drawn the murder weapon, he held up to the jury the sketch that had been drawn, and on which he had drawn a life-size wrench. At the first break, the jury that day, Mr. Bates asked if the jury could take the sketch into the jury room, and surprisingly, the jury agreed. The judge agreed. References to the wrench as the murder weapon were made there throughout the trial. Now, what's all this got to do with it? Well, Quigley, having read the transcript, persuaded Jim McGinty, then the Attorney General, to have the DPP make the DPP's file available. And guess what he found on the file? He found a letter written in October 1994 by the detective sergeant in charge of the murder investigation, addressed directly to Mr. McKechnie, and the letter asked for a senior prosecutor to be assigned, and attached to the letter was a comprehensive summary of facts, including which was a reference made to the type of murder weapon. It said that an experiment had been conducted by Dr. Cook, Chief Forensic Pathologist, in conjunction with Mr. Lynch of the WA Chemistry Centre, to test a copper anode as a murder weapon. It couldn't have been. The conclusion was that it was not, but the report said that during the experiment, a crescent wrench was also tested, which inflicted dissimilar wounds to those sustained by the murdered woman. And the letter also said that the place in the Swan River was described by Andrew was searched by the water police, and as the place where he said the wrench had been thrown, but in fact, without success, the wrench wasn't there. So the police knew, and they conveyed in turn to the DPP, that the wrench described by Andrew in his alleged confession could not have been the murder weapon. When Quigley read the report, he telephoned me excitedly. The jury had never been told the wrench drawn by Andrew could not have been the murder weapon. In fact, they were told that it was what he had drawn as the murder weapon. That was enough to get the case referred back by way of petition to the Attorney General to the Court of Criminal Appeal. I was engaged to represent Andrew. My very learned junior was Dr. James Edelman, now Justice Edelman of the High Court, and of course one of the dissenting judges with whose judgment I agree in the Bromley case that's just been referred to. He was then working in my chambers as a fairly new barrister. We're also fortunate enough to have the very competent solicitors pro bono from the firm of Clayton Utes. Once the appeal was instituted, it became possible to obtain by subpoena a lot more evidence, although most of it, none of it was provided without having to obtain orders from the Supreme Court. We were opposed tooth and nail by the DPP and the police in our attempt to get any material. But what ultimately was disclosed was a lot of things. A prosecution witness gave evidence. A young lady, Kate Barsden, who'd been a schoolgirl at the time of the murder, seated in her grandmother's car, coincidentally, just outside the jeweler's shop where the murder took place. And it must have taken place just before they stopped there, because she saw a man in the jeweler's shop who bobbed down when he saw that she was looking at him. And she described the man in some detail, and she indeed drew a sketch of the man. She turned out later to have a career as an architect. She was very good at drawing. And she noted the time. When the police interviewed Mallard, they told him that he'd been seen by a girl in the jeweler's shop. In fact, he'd been to the jeweler's shop during the daytime, some days earlier, about a week before, not on the day of the murder. He'd gone there to try to sell without success a cheap piece of jewellery. He thought the police were talking about that day. They asked him whether he was been wearing a bandana that day, because the girl who'd seen him, he said he'd been wearing a bandana. He said, "No, I don't have a bandana, but I do have a cap, so I sometimes wear it turned backwards. It might have looked like a bandana." So the police then went to the place where he'd been living during that period, a flat whose tenant was a young woman, Michelle. On the night of the murder, he'd been out. He came in, she said, that evening with his head wet. She said he was not wearing a cap. It had been hanging on a hook all that day. So he couldn't have been the man wearing the cap backwards so it looked like a bandana. So the police took that statement from her. A young policeman, took it back to the sergeant. The sergeant said, look, get her to do a fresh statement, but take out all that reference to the cap. So he did. So the girl didn't give evidence. She didn't realise the significance that the cap had been hanging on the hook all that day. So they took it out and she signed that. We discovered that on subpoena, got her original statement. And then experiments have been carried out. Analysis was made of all Andrew's clothes. No trace of the murdered woman's blood was found on any of them, not a skerrick. And there was blood everywhere in the crime scene. The police asked Andrew, how did the murderer get the blood off his clothes? Andrew said, well, he would have gone into the Swan River. He nominated the place to wash the blood off. He even said, because I know that salt water fucks the forensics, to use his language. He even identified, as I said, where it had been done. When the clothes were sent for analysis to the laboratories, the analyst, Dr. Lynch, gave a report in which he said that neither blood nor any traces of salt water were found on any of the clothing. If Andrew had been the killer and wore his clothes in the water, then surely at least the salt water would have been discovered if it washed off the blood. So Dr. Lynch was asked by the police to do a fresh report, and this time take out all reference to there being no salt water on the clothes. So that enabled the prosecution to present a case to the jury that although there was no blood found on the clothes, that was because Andrew had confessed washing his clothes in the salt water. These were some of the most egregious examples of deliberate concealment of evidence, which would not only have assisted the defence, but added to the mounting evidence that everything that Andrew had said in his videotaped interview was, as he said, merely his theory or conjecture. Another plank in the prosecution case was that the assertion that Andrew had told the police 15 different things, which the prosecution said only the murderer could have known. That was only faintly challenged at his trial, but that's James Edelman and I and the support crew, went through all of those 15 things and established that either they were in fact false pieces of alleged fact, or they were easily discovered by anyone who cared to listen to the broadcast almost day and night about the murder. So they were not, all 15 things were not things that only the murderer could have known. They were either things that didn't exist or which anyone could have known. And then the schoolgirl who'd seen the man in the jewellery shop and made a sketch when she went home. Her mother said, you better sketch out what you saw. She drew a sketch. The police took a statement from her but said, don't put anything about the sketch. We discovered on subpoena the sketch that she had made. It showed a man with fairly short hair, a very light, unshaven face, no moustache, and not long hair. Here's a photograph. You can see it. You see that? That is a photograph of Andrew Mallard taken the day of the murder. How come he was taken by a police photographer? Because he was arrested earlier that day for stealing a bicycle. But you can see the difference between what the girl described in her sketch, which was never shown to the defence at the time or the jury, and the actual appearance of Mr. Mallard on that day. And then, Michael Kirby touched on this, a taxi driver dropped Mallard, that we found, at a point about 1 kilometre from the crime scene at about 5 p.m. that day. It would have been impossible, and he had the timing worked out, and so did the girl who saw the man in the shop, obviously who was the murderer, and she noted the time, was on the car clock at 5:02. So it would have taken an Olympic sprint champion to get from the place where Andrew had been dropped off that day to where the murder took place within that short time. It gave Andrew only about 2 or 3 minutes to get from one place to the other. In fact, Dr. Edelman and I walked the distance, and at a sharp, a very fast walk, faster. Dr. Edelman was faster than me, but we agreed that it couldn't possibly have happened. So despite all this evidence, which we then got and presented to the Court of Appeal, the Court of Appeal unanimously dismissed our appeal. The decision which I described at the time was the worst, most superficial and illogical decision I'd had the misfortune ever to read. It caused my team to look the most sorrowful group that you've ever seen in your life. In fact, they could not believe the injustice of it all. And I said, well, don't worry, we're going to get special leave to appeal to the High Court, and we did. When it went on special leave application, I remember that the DPP at the time, who was opposing the application of special leave, in the course of his address, arguing that special leave should not be granted because previous special leave had been refused, to which one of the judges on the bench said, yes, but this is a totally different case to the one that went before them then. And then another judge interpreted, I think it was Justice Callanan, I think he was a racing man, who said to the prosecutor, you must admit you've got a lot of lead in your saddlebags, Mr. Fianaka. So that was, we appealed successfully before the High Court, and we ended up getting a 5-0 upholding of our appeal. And it was in the course of his judgment, he joined with the majority in allowing the appeal, but in the course of judgment, Michael Kirby observed that there were many curious features of this case at trial. The possibility that the appellant is innocent cannot be excluded. There is exculpating evidence, some of which was simply not revealed to the defence, some of which was actually suppressed, so as to deprive the defence of material by which to test the accuracy of the evidence of obviously truthful witnesses and impugn the credibility of others, particularly police. So I said something similar to the Court of Criminal Appeal, and they took me to task over that. Well, looking back on that, can it really be said that this was a case where you can be comforted by what occurred? No, it was a series of pure luck, chance, by which all of this evidence was unravelled, and the police and the people who were involved in doing that were prepared to stick to it. A Criminal Cases Review Commission would have done it so as to save all the time that was taken and used up in trying to mount an appeal again. I haven't got time, in fact, I clearly haven't got time to take you further, but the Mickelberg case, which was decided in July 2004 ultimately, but after three petitions to the Court of Criminal Appeal, 2 appeals to the High Court on special leave. Ultimately, what finally revealed the truth was, again, you could say sheer luck. The police officer who'd been one of the 2 police officers conducting the investigation into the Mickelberg case had said at the time that the Mickelbergs were arrested, but he said to Don Hancock, who was the detective sergeant in charge of the investigation, we've got nothing on them. To which Don said, don't wait, don't worry, we will have, just wait. And 5 weeks later, as Lewandowski finally admitted in 2003, finally admitted that it had all been fake evidence that Don Hancock had dictated to him. In those days, you didn't have to have a video recorded confession to have it admitted. And Don would dictate, and Lewandowski would write down the answers to allegedly was given, all fiction. And Lewandowski finally admitted that. Was that something that could have been revealed by the Criminal Case Review Commission? Possibly by thorough investigation. Lewandowski admitted, when he finally admitted that the confessions were all fake, admitted that when the confessions and their evidence about confessions, which they gave on oath, were accepted, he couldn't believe it. He said, even though there were holes in the confessions, nevertheless, the jury and the judges all accepted it. Finally, there's the case of Ostick, which is mentioned. That, I must say, demonstrates the degree of luck that plays a part in exonerating people who've been unjustly convicted. I won't go into the details of that, but after his conviction, he'd lost his appeal against his conviction. His mother just like Andrew Mallard's mother, refused to give up on him. And she went along to a dinner which was held really dealing with miscarriages of justice. The principal speaker was Reuben, otherwise nicknamed Hurricane Carter, an ex-boxer who had suffered a serious miscarriage of justice back in Canada and had been wrongfully convicted and imprisoned for a murder which he didn't commit. So he was speaking at that. She went along. She sat next to, by sheer chance, she sat next to a young lawyer whom she'd never met called Clint Hampson, and she got talking to him about his son. Clint was not only a lawyer, but he'd previously worked in the police department as a he had a forensic background, forensic science. He became interested, got onto it, discovered when he went through he got access to the police files and discovered that there was a video in the police files of a table on which there appeared to be no cigarette pack. Well, what's the significance of that? Well, the significance is that the evidence at trial was a video of the same table where there was no cigarette pack, and it was taken earlier than the one that had the cigarette pack on it. And the cigarette pack showed in the second video, taken some days later, the cigarette pack had blood of the deceased, the murdered woman's blood was on it. So they seized on that. They got that by good luck. She would never have had the opportunity to get to the access to police files. She wouldn't have known where to go, nor would she appreciate the significance. And that, among other things, caused the Attorney General to grant a second petition, which was mounted on that basis and also on the basis of other evidence which was discovered, which was never disclosed. As a result, finally, the Ostick got back to court a second time. The Court of Criminal Appeal here unanimously upheld his appeal and ordered there be a retrial, and the retrial was conducted, and he was in very short time acquitted by the jury and went on his way, but having spent in the meantime something like, I think, 10 or 11 years in jail. It's a long time. So what do we make of all that? It cannot be said that, and I think Michael Kirby said, it cannot be said that the right of second appeal is enough. It's a good start, the right of a second appeal, nor is it enough to know that now we have legislation, I think in every state, certainly in this state, that confessions generally cannot be admitted, save in exceptional circumstances, unless they have been video recorded. But it should not be left to chance, as it was in these cases, for justice to prevail. The right of second appeal is of not much value unless the person who seeks to exercise that second right is able to get access to all of the information. And strikingly, to illustrate that point, in the case of Mallard, after he had been acquitted and set free, as a result of huge pressure, an independent inquiry was instigated by a very, very experienced investigator from Scotland Yard. And he discovered that there was in prison a man who had been convicted of a murder using an instrument which was the kind of instrument that must have been used on the deceased jeweller's skull. And just as in the case of the deceased jeweller, there was some inexplicable traces of Prussian blue paint, which no one could understand were there. So in the case of this other murder that had been inflicted by a person who was now in prison. How the two were never connected, I don't know, but the Scotland Yard investigator discovered that. He also discovered that in the police files, the WA police files, there were no fingerprints of the scene, as they had said, and we sought on subpoena were there any fingerprints. The answer was no, but there was a palm print, and the palm print matched the palm print of the man that was in prison for a murder committed in much the same method as the poor jeweller was murdered. When I raised that with the DPP and this was discovered, I said, well, and the police, why didn't you discover when we asked for fingerprints the palm print? To which I think the specious answer was, well, you didn't ask for palm prints, you only asked for fingerprints. So an independent investigation conducted by the Criminal Case Review Commission back in the early part of the Mallard saga would have revealed what we ultimately didn't discover until much later. So I urge all of those in the audience to agree that there should be a Criminal Cases Review Commission. I've been urging that for over 2 decades, and I recently inquired of the Attorney General's office in Western Australia, well, what's happening? And the answer was, well, it's still on the agenda for the Attorney General's conferences, which we held from time to time. And what's the prospect? Well, not unless everyone agrees to it. I don't think that's a good answer. I think every state should try to institute a Criminal Case Review Commission. Thank you for listening to me.